Good morning. Are you Courtney Joseph?
Yes, ma'am.
And this is 23 DCCR 0167. Ms. Joseph is on probation for assault of a peace officer. There's a motion to revoke, and will she waive the formal reading of the motion?
Yes.
Ms. Joseph, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 11th of 2023 for assault on a peace officer, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of driving while intoxicated with a child under 15, June 21st of 2025. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 and count 3 both allege that same offense, same day, different children. And again, are those true or not true?
True.
Count 4 alleges that you were arrested for the offense of resisting arrest or search or transportation June 21st of 2025 in Orange County. And is that true or not true?
True.
Count 5 alleges that you failed to remain in Jefferson County, Texas as directed, and that you were in Orange County, Texas on June 21st of 2025. And is that true or not true?
True.
Count 6 alleges that you were at a location other than your residence at approximately 10:17 p.m. on June 21st of 2025. And is that true or not true?
True.
Count 7 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you were arrested for driving while intoxicated June 21st of 2025. And is that true or not true?
True.
And then count 8 alleges that you are behind in your court-assessed fees as of July 17th of 2025 in the amount of $1,825. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 8 freely and voluntarily?
Yes.
And did you plead true to those counts because they're all actually true?
True.
All right.
Yes,
So I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. However, it's my understanding that you've reached an agreement with the district attorney's office. Mr. Nichols?
Your Honor, our intent is to have her do 120 day for day in the jail.
By this point, the legal posture is settled. When every allegation is admitted without resistance, the hearing quietly transforms. The courtroom isn't weighing evidence anymore. It's weighing judgment, credibility, and whether accountability can still be structured instead of imposed.
Jail as a sanction, understanding that this is a rare opportunity. We're waiting the resolution for Orange County cases, that she would be on no tolerance from this point on, and have to deal with Orange County however they see fit.
And Your Honor, she has been going to ever since she got out of jail on her own without any suggestion from me. She's been going to outpatient treatment 3 times a week, and she's got a job, and so even just going to follow. She did that out without talking to me. Just called me and said, "Hey, I'm getting some help." So.
All right. So it's your understanding that you'll go into custody, do 120 days, that you'll still be on probation in order to follow all the rules and conditions, including any others that I think are appropriate. Is that your understanding?
Yes, ma'am.
Then at this time, based on that, this is an excellent opportunity, Ms. Joseph, because the offense that you're on probation for, with a violation like this, you could go to prison for 2 to 20 years. So I want you to take advantage of this opportunity that you're being given today, because if you don't and you're back in here on any violations, it will likely not go this way. You understand?
Yes, ma'am.
So I'm going to, again, find counts 1 through 8 true. I'm not going to revoke your probation. I'm going to continue you on probation. I am going to extend your probation by 1 year. I'm going to order the 120 days as a condition, day for day, as a sanction for these violations. I'm also going to order that you're on 0 tolerance. So when you get out of the 120 days, you have to do everything right. You need to make some payments. You're getting behind on those. Follow all of the rules and conditions. I am going to order, since you're going to treatment, it obviously appears that there's an issue. So I'm going to order when you're out that you also enter and successfully complete the JCDI program. It's an outpatient treatment program. You'll be able to continue treatment, and hopefully you won't end up in any position like this. Do you understand?
Yes, ma'am.
All right, then. Good luck to you, ma'am. You can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you, Mr. LeGros.
Thank you. Yeah.
All right, so Mr. Franklin, in cause number 25, DCCR 1005, the state has elected to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from May 10th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
Take that out of your mouth. You're going to walk up in court with a toothpick hanging out of your mouth? Did you enter your plea of guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Smith? Do you fully understand those? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year term in prison, but that would be probated for 5 years. I don't, with the history,
Your Honor, he's successful. I know there's priors.
I'm fine with probation. I just don't like the fact that if he does not complete it, that 5 is, and
Would the court,
I just think on those.
This moment reveals something important about judicial discretion. The concern isn't the plea itself, it's the future leverage. The court is preserving flexibility, ensuring that consequences scale with conduct rather than being locked into a number that might later feel disconnected from reality.
since we were limiting it, would the
Since you're
court set the
limiting-
10 over 5?
Yeah,
Where
yeah.
The probation term's not any different, just the
Yes,
possibility of.
absolutely, because on all of these, and honestly, the one before this, I almost said it and I probably should have. I would much rather have, because depending on what the violation is, it may look very weird to do a 3 or a 5 if they violated their
I understand
probation in
that.
some egregious way. Do you want to talk to him about that? I'm willing to accept the 5 years of probation, but the actual punishment, if he violates, is, I'm not going to agree to a cap at 5 on that.
The only reason it's lower than the other one is because the offense itself.
That one, it didn't have the history.
And I know why she did this. He successfully completed a probation about the time this happened, a 10-year probation out of Liberty County.
Yeah.
So I think that's the reason. But I understand the court's concern.
Yeah, I just want that entire range of something, when you have history. The other one didn't have any.
He had one
history.
old state jail.
Okay,
But
yeah.
nothing that enhanced.
Right.
It was like first.
Which means that it's virtually compliant.
It's fine.
So the agreement, I want to make sure, as it stands on the paperwork now, the agreement was for a 5-year term in prison that would be probated for 5 years. And it's my understanding that you will agree to a 10-year term in prison, but it will still be probated for 5 years, which means if you violate, I could give you that 10 years, or something in between, but it's not going to be capped at that 5. And you agree to that. With everyone's permission, I'm going to make that adjustment on the written admonishment.
No objection, Your Honor.
And that was a $500 fine as well. Is that your understanding? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Franklin is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done by probation. It'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Thank you.
Yes, sir, thank you.
Thanks, Judge.
Thank you. Good morning. Are you Aaron Shetley? And this is 24 DCCR 0776. Mr. Shetley is charged with assault, family violence by impeding breath or circulation. And what is the announcement?
Gotta get into the small field on that one too.
I know it's a
Okay.
little bit over, Judge, but it's the
It is.
same deal where they have been in contact, and I know that this case was originally set a week ago, they got moved a week.
Right.
And so it's another one where they're going to have a conversation about how to work this out.
So I'll set this one. On this one, just due to the age, this will be the last reset. Make sure you stay in touch with your attorney. He's going to visit with the district attorney. You need to get an announcement at that next court date. All right, thanks. You're free to go, sir. Good morning, sir. You're Guadalupe Reyes, and this is 25 DCCR 1422. Mr. Reyes is charged with aggravated robbery, and what is the announcement?
Judge, Mr. Washington needs to get on, his first time getting
Okay.
on our discovery portal, so
All
I'm
right.
going to get him instructions on how to do that and get him.
Sure.
There's a lot of discovery in this case, and so I'm going to get him down the road to
Perfect.
make sure he has access.
All right, so what I'll do is just reset the case about 30 days. That'll give you some time to get all that information downloaded and go over it with your client, and we'll see where we are at the next court date. Stay in touch with your attorney. He'll let you know when you need to be back. You're free to go. Yes, sir. Thank you. Good morning. Are you Lisa White? And this is 25 DCCR 0923. Ms. White is charged with aggravated assault with a deadly weapon. Mr. Parker, what is the announcement?
Your Honor, we're asking for one more reset. There's a video that I need to get. I didn't know, and I think Mr. Nichols wants to talk to the victim as well. If we get one more reset, I need her to come in my office. She communicates with me.
Sure.
As the docket moves quickly, a pattern emerges. These brief resets aren't delays, they're pressure points. Each one quietly transfers responsibility back to the defendant and counsel, signaling that preparation, communication, and follow-through are now the deciding factors.
Correct.
All right, so Ms. White, I'm going to reset your case, a normal reset. Make sure you stay in touch with Mr. Parker so that once he gets the video and any other evidence, you can visit with him, go over all of that, and we'll see if we can get an announcement at the next court date. You're free to go. Hold on just a second. Good morning, sir. You're Corey Richardson? And Mr. Richardson is charged with solicitation of prostitution and cause number 25 DCCR 0249. Mr. Crenshaw?
Your Honor, last week I visited specifically with Ms. Molfino on this case since Kobe was in trial. I believe we're going to have this resolved with a plea agreement. If we could come back on this one as well as in 2 weeks, I'm very optimistic this one will in fact be a plea.
This isn't something you guys can take care of today since Mr. Hoffpower's here? You've been on this since February of last year. It's been a year.
We've got an offer in this case, Judge. I'm not aware, I hadn't talked to Ms. Molfino about any conversation about it. I've given her an offer before with counsel. And there was some indication they were going to speak to somebody above me.
All right.
I spoke with
Right.
Mr. Giblin, and he said to speak with Ashley about it, which I did last week. And she said that she was ready to make a decision, but she wanted to talk to Kobe about it first. And I don't think that ever happened because he said he hadn't talked to her.
Okay.
But
2 weeks, last reset.
this really will be a plea.
All right. So Mr. Richardson, stay in touch with Mr. Crenshaw. We'll see you back in 2 weeks. Good morning. Are you Jace Dunn? Yes, ma'am. And will your client waive the formal reading of the indictment? Mr. Dunn, in cause number 25, excuse me, DCCR 0896, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Comerford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Dunn is not competent?
There is not.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and that you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. It'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop on your way out of the courtroom and talk to probation, and she's sitting at that desk right over there. All right? We'll see you back at sentencing. Thank you, Mr. Comerford.
What stands out across this docket isn't punishment, it's calibration. The court balances admissions, history, and opportunity, applying restraint where structure might still work and caution where risk remains unresolved. Each ruling leaves the door open, but not unguarded. If you found this breakdown insightful, hit like, share your thoughts in the comments, and subscribe for more real courtroom analysis.